review application, an order which your lordship has passed in an FAO while sitting in civil bench 1.
Mostly Gauri to
Please.
supplementary item. No, actual. Which one is it? Supplementary item 13. Yes.
This case is pending. Opposite party, Corporation of India has submitted affidavit. They have not submitted it.
Yes, where is FCI? Wait for some time. Just wait for some. No, that is already adjourned. We'll adjourn it because we'll adjourn it. Wait for some time. He was intimated, no?
Intimated, he's coming. Seems that he has some problem with his leg. So
Okay.
he's coming. He's reached already.
Okay. No issue.
He's coming.
Wait. Now think over it. The allegation is serious.
So, look, I need some time to file my affidavit.
You are for you are for him.
He has contacted me to I have to appear for it.
Okay, you appear for him, but you should not avoid.
Lordship.
Earlier lawyer said no contact.
No, myself was the.
Or you
I was the initial use of
It's not that he cannot take a
He
right.
came to me, Lordship, thereafter he.
The director summoned him. Summoned him and understand that you have to.
Okay, at least that part is over. Now we will dispense with his personal appearance. But he should, if he misses anything or he stops, then we'll.
No, I have already intimated him, Lordship.
It's an obstruction to a judicial process. It's not there. Certain times you cannot, without affidavit, make a determination.
Let him come, Lord.
Yes.
Wait.
Yes.
Any
Any criminal case file in that case?
My Lord, actually, what happened?
What is the stage of that criminal case?
There, I thought he can.
Okay.
Okay.
Okay. Okay. Yes, next case. Item? Two.
Here in the case, out of an incident matter, the criminal case and percentage proceeding was finished.
Where is the first charge memo?
My lord, first charge member is the page 22.
Page
20.
Mr. Suti, are you preparing?
Yes, I am.
You are having the record.
Record no, my Lord. I have no. We have filed affidavit, but the record is not there.
Okay. Where is the
In some cases, my Lord, what happened? Due to the incident, my Lord, my Lord, the petitioner was, my Lord.
This was that slippery man, something like that.
Yes.
What happened, my Lord, ultimately departmental proceeding was dropped. He was absolved. And subsequently, what happened in the meantime, my Lord, one man inquiry was given by retired judge of our Musahari, my Lord, High Court. So this report comes later on. So by virtue of this report, my Lord, taking into account of this report, my Lord, they have again issued so much.
But suppose if same incidents already a proceeding was there, subsequent is only because High Court says it was not within, might not been within the commission. That already departmental proceeding was done.
And that has been dropped. And due to receipt of the one-man committee report, the so was taken. That is the case.
What is the law?
In departmental discipline and procedure, there is no such procedure.
But are they debarred from doing that? Satisfy us that they are absolutely barred in taking and that these two are different, not the same. Where is the first?
First,
Give us some supporting law.
Yeah.
To make the things easy, or it is up to the court to take
No,
out the law?
Our I have judgment.
Okay. So as the first Sukkot.
Well, first focus notice is just page 22. You are hereby required to propose the section of the Assam read with the rules of the Assam Police Manual, Part 6 and the Article section of the Constitution. Rule 7 of the Assam Service Discipline Institute 1964 as to why any to the panel prescribed in the afforded should not be inflicted on the public charge based on the statement of it. And while you are posted at developer as IC or
Okay. Okay. This is the first
this is the
Sukkot.
first focus. And the
Statement of allegation is page 24.
page 24.
Okay. Where is the inquiry report?
And the final report is there. Final order, but it is just page 30.
No, where is the inquiry report?
Page 25. Reporting.
It's on detailed report.
25. Page
Final order on page 34. The full focus to page 34.
There is a stay.
Yes.
What is the urgency?
Well, I think what has happened is the vacancy of case method.
Hmm.
Its promotion is ago. subsequently by the sub person continued to promoted due to pendency of the case. Case has not been.
So now inquiry proceeding is stayed after appointment of inquiry.
Yes, yes.
Okay, so as the judgments.
I have the photocopy of the inquiry.
Admittedly, the same incident.
Same incident,
Yes.
same incident. That is true.
First one, Mother AIR 1971,
Hmm.
SC 1447, para 13, KR Dev versus the collector.
Para
Para 13.
okay.
Then Mother next 2005, TCL 457, para 5.
Hmm.
2005, TCL
Hmm.
457, para 5. So Mother, the last photo. Forward to vote the second. Fine.
Okay.
Then Mother another one.
Okay, no, nothing, not necessary.
Yes.
Lordship, that is only, Lordship
Ah.
can only see it as a
We
property.
see, will now go to your affidavit.
Yes.
What is your stand in the affidavit?
Our stand is, that is due to inquiry report.
Where is that?
Yes, yes, no, that's it.
I think paragraph 11.
Para 11.
Oh,
11
yes.
and
11. One-man committee. Answering the opponent states that the government of Assam by notification dated 11/9/2013 appointed one-man
Just
commission.
give me 2 dates. When earlier order of exonerating him, your order and date of inquiry report?
the date of inquiry report
17 January
17,
2015.
17.
January 2015.
Just first show cause, date of show cause,
first focus on 23/8/2013.
23/8/2013.
2013. Then
Okay.
report 17 August
First show
2013.
cause. Report
17 August 2013.
17 August 2013.
And
Report. And
Final
final
order.
order
inquiry order number 17/1/2015.
17/1/2015.
And my lord, in fact,
Okay, okay. Just let us see the this is your case. Okay, now let us see the appointment of inquiry commission.
This is my lord, paragraph 11.
11/9/13 commission appointed.
Yes.
Is not it?
Actually, the inquiry report was submitted by one-man inquiry committee
Committee.
headed by so 1/11/2017. Requested Director General of
1/11.
2017. Page 7 of that. Requested DGP Assam for taking disciplinary action against S.A. Noyadul Islam and Titan officer himself, Devapara OP, for failing to tackle the situation due to his reckless action directed by the Inquiry Commission. Therefore, the Director General of Police Assam set aside the order of the disciplinary authority, that is Superintendent of Police Bongaigaon, who disposed of the departmental proceeding on 17/1/2015 and ordered for a de novo departmental proceeding against the petition. Inspector Noyadul Islam didn't IC Devapara so memo. That's why, my lord, they have taken up this second. And this inquiry report, my lord, you can see only one paragraph. I have a photo. I mark it red light, my lord, from it. This is the one of the list of the inquiry.
What it says.
This is, my lord, why on the basis of this,
What it says. See,
this is the responsibility.
see the blank fire was ordered by Niazul Islam so and so so and so. In exercise power as a leader of the party on the spot to save the life of the police personnel, government property, that is arms and ammunition. The inquiry report says that it was a situation where those were snatched. The situation as shown in the said IC was too serious to obtain prior order from the higher authorities for ordering blank fare to disperse the crowd. The district and civil to under such the lapse in tackling the situation.
That is the problem. Only because they have started it, because they retired judge has one man inquiry has imposed responsibility to the source. That is the only ground. Otherwise, in normal cases, second source notice they cannot started by issuing source notice. Tinovo is part.
Now, any challenge to this decision in the inquiry report?
Inquiry report is not there.
No.
How do we comment on that inquiry report, findings of the inquiry report? Okay, we need not comment. We can say that already that part was complied. Will not quote any judgment or all. Will shortcut it.
Yes.
Not necessary to always give
Yes.
this. Heart, Mr. R. Islam, Garnet Council for the petitioner. Also, Mr. T.C. Sutia, Lanet Additional Senior Government, representing the respondents. Presenting the petitioner is a member of Assam Police, is a member. What is your post? You are
Inspector.
Huh?
Presently working at CIT.
Now presently,
CIT.
and at that point of time.
At that point of time, you are sub-inspector.
Okay.
In that
Uh,
developer.
the petitioner is presently serving as a reserve inspector or
CIT.
CID inspector in the office of the
CID.
In the office of the CID Ulubari. While the petitioner was posted as in search, at Deborpara Police Outpost under Morioni Police Station, Jorhat, Assam, an incident of firing occurred wherein one minor boy was killed and another person got injured. Full stop. On the backdrop of aforesaid incident, the petitioner incident, the backdrop of the incident, with the backdrop of the aforesaid incident, the Superintendent of Police, Jorhat, Assam, issued a show-cause notice under Section 65 of the Assam Police Act 2007, read with Rule 66 of Assam Police Manual, Part 3, and Article 311 of the Constitution of India, and also under Rule 7 of Assam's Services Discipline and Appeal Rule 1964, asking the petitioner as to why any penalties prescribed in the said rules should not be inflicted on the petitioners on the on the on the for on two charges full stop. The aforesaid on the which have three charges. The charges are quoted herein below. Page 22, 1, 2, 3, pencil mark. Okay. Thereafter, the petitioner, from a date below, 23rd of August 2023, issued a show cause on 23rd of August 2013. How can you reply on 17th August? Huh? Show cause is of 23rd. Okay, where is your reply?
Reply.
How do you know what was your reply? Thereafter, petitioner replied to such charges and denied the allegation. Full stop. An inquiry officer was appointed to inquire into the matter. Full stop. Inquiry, a departmental inquiry was conducted wherein the petitioner participated. After completion of the inquiry, the inquiry officer submitted his report The findings of the inquiry officer is to the effect that due to assault by mob upon the police party inasmuch as to save the life and property of the life of the police personnel and public property, the blank firing was resorted to inasmuch as the petitioner and other police personnel were badly beaten up by the unruly crowd. It was also finding that the crowd tried to pull the petitioner as well as one Tuleswar Gogoi to cut them to pieces with sharp, deadly weapons. Accordingly, the inquiry officer concluded that as already two policemen were badly injured and finding no other alternative with the violent armed mob which intended to kill the police party at the spot, controlling fire was opened into the air by the police. Thus, the inquiry officer exonerated the petitioner from the charges. On the basis of such inquiry report, the disciplinary authority thereafter passed an order on 17/1/2015 agreed with the findings of the inquiry officer and concluded as following. Page 31, pencil mark to pencil mark. Okay. Thereafter, on 2nd of August 2018, isn't it? A fresh show cause notice was issued proposing a de novo inquiry. Full stop. Such de novo inquiry is under challenge before this court. This court, under its order dated 9/12, 9/12/2019, you take your seat. 9/12/2019. Nine 2019, while issuing notice, stayed the further proceeding of the proceeding pursuant to the notice dated 29/10/2019, isn't it? It order notice to 2010 to 2019, huh? Okay. Islam Learned Council argues that when, after a detailed departmental inquiry, the petitioner has been exonerated by the employer, the employer shall have no right to have a de novo, initiate a de novo inquiry in as much as the employer has as much as the employer has clearly concurred with the finding of the inquiry officer. Concur with the inquiry officer. Par contra, Mr. E.C. Sutia, Learned Council, representing the respondent employer, submits that though the petitioner was exonerated by the department after a due inquiry, however, the de novo inquiry has been initiated by virtue of a recommendation of an inquiry commission. By virtue of a recommendation of one-man inquiry commission to inquire into the incident of firing that took place at Hamlai Tea Estate in Jorhat district on 18/8/2013. Full stop. Mr. Sutia contends that the government of Assam, by its notification dated 11/9/2019, appointed a one-man commission to inquire into the incident. Full stop. Accordingly, the incident by a retired judge of this court. Full stop. Thereafter, the one-man inquiry commission suggested for fixing responsibility on the petitioner suggested for fixing responsibility on the on the petitioner, that is on the petitioner who was in search of Deberpar outpost. Accordingly, the Joint Secretary to the Government of Assam, Home and Political Department, by its communication dated 1/11/2017, requested the Director General of Police Assam for taking disciplinary action against the petitioner for failing to tackle the situation due to his tactless action as directed by the Inquiry Commission. And accordingly, on the basis of such communication, the Director General of Police Assam set aside the order of disciplinary authority dated 17/1/2015 and ordered for a de novo departmental proceeding against the petitioner, and accordingly, the show cause notice was issued. Impugned show cause notice was issued. Full stop. Mr. Sutia submits that as the Inquiry Commission has recommended for a departmental proceeding against the petitioner, the state is left with no other option but to initiate a de novo proceeding. Therefore, such action cannot be termed as an arbitrary action, and therefore, such departmental proceeding should not be interfered with. Full stop. I have given anxious considerations to the arguments advanced by the learned counsel for the parties. Peruse the material available on record. Full stop. Mr. Sutia also produced the recommendation of the one-man commission, which this court has done through. Full stop. Where is that police manual and rules? What that suggests?
What inquiry of the discipline authorities?
No, that rule they have cited some rule. No? We want to go through it because we'll have to quote it. That is vital. At least the rule portion of the rule, police manual is a big thing. Rule 66 of Assam Police Manual Part 3. Section 65 of Assam Police Act. Are you having?
No.
And you are coming to. After hearing at some length, Mr. R. Islam, learned counsel submits that he may be permitted to produce section 65 of Assam Police, he may allowed to rely on section 65 of the Assam Police Act 2007 as well as the rule 66 of Assam Police Manual Part 3. Accordingly, matter stands adjourned. Please this matter on Monday. Bring that. At least we have to quote it. What is that? Whether they're dictating a judgment.
Monday. For delivery order.
Hmm?
For delivery order.
We'll fix it. will dictate on that. The rest part will dictate on that. Almost this is complete.
Complete.
We'll have to just quote these two rules and what is the implications of
Main
this. You can argue and go, but we'll have to pass a judgment. That judgment is binding upon almost all the courts except the division. So you cannot commit mistake. You should understand lawyer's job and judge's job are two different things. If you can also have
No,
part
I will
can-
bring it. I will bring it.
Bring it from the here.
you'll have to do some hard work. It's not that everything will be done by the judge. We'll interpret, but at least I need the book. I know I don't have that.
Some
And police manual is it's a voluminous. Part 3 specifically is there. What it says. Some discipline and appeal rule everybody is having. What is 65? I forgot. What was that? Item? One. Yes. Yes, what happened to the police case? Why are you avoiding? We have serious doubt upon your appointment. We'll ask for a CBI inquiry. Tell the truth. সঁচা কথা কওক আহক আগুৱাই আহক হৈছে?
85 মই ট্ৰেইনিং কৰিছো 85 বৰ্তমানলৈকে চাকৰি কৰিয়ে আছো
নহয়, চাকৰি কৰিছে বুজিছো, কিন্তু আপোনাৰ কথা হৈছে আপুনি যিটো মানুহ চিলেক্ট হৈছিল সেইটো আপুনি নহয়ে।
নহয় তেওঁ আৰু মোৰ ঘৰ বহুত নামটোহে একে কিন্তু তেওঁ আৰু মোৰ ঘৰৰ মাজত 3 কিলোমিটাৰ ডিফাৰেঞ্চ
আপুনি এতিয়া যিহেতুকে আপোনাক কৈছে নহয় বুলি আপুনি হয় বুলি দেখাব লাগিব।
হয় মই মদন মোহন
আপুনি হয় বুলি এতিয়া দেখাব লাগিব। যদি মিছা কথা কৰিছে তেওঁ শাস্তি পাব, আৰু আপুনি যদি কৈছে আপোনাৰ বিপদ আছে। সঁচা কথাটো ক'ব যি কয়।
হয়।
সঁচা কথা ক'লে অলপ বাচি যোৱাৰ চান্স আছে।
Retiring by April, Lord.
Whatsoever,
Lord.
সঁচা কথা ক'লে বাচি যোৱাৰ সম্ভাৱনা আছে। দুইজনকে কৈছো, পিটিশ্যনাৰকো আপোনাকো। পিটিশ্যনাৰেও যদি মিছা কথা কৈ কেছ কৰিছে তেওঁৰো বিপদ হ'ব, আৰু আপুনি যদি কৰিছে আপোনাৰো বিপদ হ'ব। চ' সঁচা কথাটো ক'লে বিপদ হ'লেও বাচাৰ সম্ভাৱনা আছে। এডভাইচ হিম।
Yes. And that case is the evidence.
এভিডেন্স ইউ ফাইল এন এফিডেভিট। আৰু এই উকিলক দি পেলাই আপুনি এনেকে নোহোৱা হ'লে নহ'ব নহয়।
মোৰ মাজতে অসুগল প্ৰেচাৰ ষ্টক দুবাৰ হ'ল হাৰ্টৰ উপকাৰ আছে ন
খবৰটোতো দিব লাগিব, এটা কেছ চলি আছে, আপোনাৰ চাকৰিৰ কথা আছে,
হয়।
পেঞ্চনৰ কথা, ইমান
এতিয়া
সহজ
কওক।
নহয়।
তাৰমানে মই ফিজিকেলি
আৰু আপোনাৰ এগেইনষ্ট চিৰিয়াছ এলিগেশ্যন যে আপুনি মানুহটো চিলেক্টে নোহোৱা বুলি লিখি পেলাই অভিযোগ দিছে।
নাই চিলেক্ট গোটেই তেওঁলোকৰ যিখিনি হেৰি আমাৰ এপইণ্টমেণ্ট লেটাৰ মোৰ লগত আছে, ট্ৰেইনিঙৰ লেটাৰ মোৰ লগত আছে,
Keep all down.
চাৰ্টিফিকেট মোৰ লগত আছে গোটেই
ঠিক
মই চব
আছে।
এখেতক দি দিছো আৰু
হা?
গোটেই দায়িত্ব আৰু
You have given me
Keep the, if
Okay.
necessary, will call for the,
original.
you file an affidavit.
Lord.
Full stop. Pursuant to this court's order dated 19/12/2023, the respondent number 5 is personally, respondent number 5, namely Madan Mohan Nath, is personally present. Full stop. The learned counsel representing him prays that he may be granted a chance to file affidavit. Full stop. As the allegation is very serious, allegation made by the petitioner is very serious, and that for proper adjudication, affidavit of respondent number 5 is necessary, a last chance is given to file such affidavits. Affidavit be filed within a period of 3 weeks from today. List this matter on 29th of February 2023. 2024. The personal appearance of the respondent number 5 is dispensed with.
But my prayer would be, Lord, petitioner is not there, Lord.
You have a copy,
Yeah.
ask him, he will definitely will give,
And
or he might have also a copy,
and
Mr. Dhar.
affidavit filed by my friend also.
Okay, what is, Dhar, what is your stand?
I don't know. You stand that we have taken so at least it's a matter of question, but for our finding is we are going with.
Okay.
So we have any doubt because that we have been okay. He has been parchment from day one. Suddenly in between from nowhere this person.
Okay, you have taken that stand.
That is there.
Okay, we'll see.
No.
If necessary, we may seek the record also. Be ready with that. Huh? We will not record it, but or we should record it so that you get a handle. Uh,
No, I can.
okay,
It's required. I
okay.
Obliged.
But be in touch with, give the phone number.
Yes, হয়
হা
হয়
আপুনি আপুনি নাথাকা কাৰণে কোৰ্টৰ সমস্যা হয় নহয় কি সিদ্ধান্ত ল'ম আমি আপুনি এফিডেভিট ফাইল নকৰিলে আপুনি এফিডেভিট ফাইল নকৰিলে তেওঁ যিটো কথা কৈছে আমি সঁচা বুলি ধৰি ল'ম আপুনিতো না বুলি কোৱা নাই গতিকে তেওঁ কোৱা কথাটো সঁচা
অসুখৰ কাৰণে ভুল হ'ল ক্ষমা কৰিব
এইটো নকৰিব
মোক
হা,
লাগিলে
এইটো
মেডিকেল কাগজ পত্ৰ গোটেই দি দিম
ঠিক আছে Sutia, where is Sutia?
My lord, he has done report number 5. I will appear.
Wait for some time.
I have the record, my lord.
Oh, you have the record. Okay.
I,
You are, yeah. Oh, you were there, na?
Yes.
Okay. Oh,
I am
great.
just placing it before your lord. দুজন নামে আছে এই দুজনের নাম বিজয় কুকুটিয়া এফআই ফর ইন্সপেকশন দুটো
This is pursuant to Upendas. Our concern is like this. Just the quit. Suppose, admittedly, she was appointed immediately on death of her husband.
but that my lord that cannot be called a compassionate appointment because compassionate appointment has to go through a my lord a procedure DLC SLC
No, that at that point of time, there is no, these were a far earlier to Achyut Ranjan.
but
This was far earlier to it. What was the occasion to appoint her immediately after her death as a casual worker? Her husband was a rank of grade 3 or grade officer rank. Grade 3. That is what we want to know. What preceded her appointment?
my lord that,
Out of the world, you will, then we'll presume it. Out of the world, will you appoint a person? Okay, appoint her as a casual. What is the correlation between her death of her husband and her appointment? See, we are in a read court. We know our limitation, but we are at the same time in an equitable court. And we want your assistance in this regard.
my lord I have tried that is what because of
But
that
these
only-
are all subsequent to Achyut Ranjan.
They are-
Not Achyut Ranjan, Upendas.
my lord there is no record in the office regarding her appointment anything my lord we could not find
When your husband died, you have filed affidavit.
They have filed
We have filed a affidavit,
my lord. They have stated that on death of my husband, I was. They have not said that I was appointed on
And
compassion
why these two writ petitions?
to defend.
Both were same. What was
I
the
didn't-
stand in affidavit?
I didn't. Affidavit also.
Okay. Whatever in the material will go on that with our limited scope.
para 4 just I'm reading my lord what is the
No, not today. Not today.
not present, my lord.
We'll think over it.
My lord.
You also come prepared. Thoroughly. You will have to argue a level apart. Not that you'll say the facts and give me because of this. You will have to go to a different level to get a favorable order. Implications, nexus, correlation, conduct, meaning and purport. We'll have to go that
He
way.
has to overcome one thing, my lord, that he was serving for almost 23 years.
Hmm.
In between of these 23 years, he was being paid as a casual employee, daily basis. He never raised,
And the bargaining power.
he never raised
Hmm.
issue of a regularization during a period of service.
And the bargaining power. Okay. So we cannot give you a relief like that, that this is this. Because Mr. Dhar is arguing, he has said, you have been in casual. You are stopped from raising at this stage. You have never raised your situation. So therefore, you will have to go one stage apart, not like stating that this he was joined on such and his husband died and so therefore give me. Come prepared thoroughly. We'll take it as a test case. We do not know which side will you go. We'll at least give a try.
Right.
Okay.
On 15th,
On 15th. Heard at some length, list this matter for further hearing on 15th. Full stop. Mr. Dhar submits that here is
From 15, 16, 17, 18, I won't be here.
okay.
Somebody else will be here, no
Huh?
problem. Or else, if my
No,
lord
no.
wants my assistance, then my lord after 20th, my lord, I won't be here. In,
they would be there, my lord. Earlier it was for the
Okay. Huh? 28th of 15th, 28th. 28th of February, 2024. Mr. Dhar fairly submits that no record is available. No record is available as directed to be produced by this court under its earlier order relating to the appointment of the petitioner. That being so, the matter will be taken up on the basis of available material on record on the Netflix. Okay, let us see.
Hi. My teacher.
Who will give instruction? Mr. Gogoi. Or whosoever.
Yes.
Gogoi, learned head, non-disburse of medical expenses. Have the instruction.
my lord. Yes. In fact, my lord, this is a disputed amount. Otherwise, my lord, whatever was the admissible amount that has been paid.
Okay. Just give a instruction how
Just
you are
for
not
why
paying
it has
that.
been rejected.
Okay. Mr. Mr. Gogoi, learned standing counsel for health department, praised for and is granted. It's a recent 2023 matter
Right.
granted. When
At least 3 weeks maybe.
3 weeks time to obtain instruction in terms of the instruction in terms of this court's order dated 22/12/2023. List after 3 weeks.
Bless.
Just note it down the earlier order. You just have it.
Affidavit in opposition is yet to be filed. 2 weeks,
File, there's a recovery already rule has been issued.
2 weeks time may be granted will be filed.
You file it. The learned standing counsel for FCI is granted further 2 weeks time to file affidavit. Full stop. List this matter in the order column on. After 2 weeks, give a date. 21st of February. You file an affidavit. Got it.
Right. This case argument has been
Just will record the facts initially. Let us see. Heard Mr. Learned counsel for the petitioner. also heard Mr. E.C. Sutia. Mr. Sutia, that case,
Your local
printing and technology,
of press
press,
printing and press
press,
printing.
tech,
Press,
whatsoever, press
3 and 4.
3 and 4.
Huh.
So I fixed it on
20.
28. No record is available.
Record is actually we asked them. There is no record.
No record.
Only
Okay.
what is record is there. They have sent it. We have annexed in the FM.
Okay. So that we said that since no record is available, so we'll proceed on the matter.
According to-
So ask him to argue him and you
Yes.
or whosoever.
on 20th. Yes.
This is test. What is the impugn order? 9/7/2021. 11/10/2021.
11. Annex 4, page 20.
The present writ petition is filed assailing an impugn order dated 11/10/2021 issued by the respondent number 6. Is not it?
Yes.
Whereby in exercise of power under subclause B of provision 2 of Article 311 of the Constitution of India, the petitioner, namely UBC/295 Raj Babu Singh, was dismissed from service with immediate effect. It is the order.
Yes.
This is only impugned. Anything before that? No.
No.
The background facts leading to filing of the present petition can be summarized as under. The petitioner, while working as constable within bracket UBC/290, you take your seat, UBC 295 bracket post, and was posted at Fancy Bazaar Outpost, Guwahati, an FIR was lodged before the officer in charge Lotus Police Station on 23/6/2021 that on the said date around 6:45 AM, some persons forcibly trespassed into the house of the informant and kidnapped his father from the house. Full stop. On the basis of said FIR, Lotus Police Station case number 217/2021 was registered, initially under section 448/365/34 IPC and later on section 364A/120 within bracket B IPC was added. The petitioner was arrested in connection with the aforesaid Lotus Police Station case on 29/6/2021. Full stop. Subsequently, the petitioner was granted bail by this court by an order dated 29/9/2021, passed in bail application number 2510/2021. Thereafter, the order dated 16/10/2021 was passed, impugned order dated 16/10/2021 passed, dismissing the petition from service as discussed herein above. Such order is under challenge.
Dispute order number 10, 1110.
1110. 1110. Just I'll verify it. 11/2021. What to do? He has written in some places as okay, not necessary. He was informed. Okay. Okay. 11. Then paragraph 4 of this judgment. My dear. Paragraph 6, paragraph 7, paragraph 8, paragraph. Itu apa? Sutia. Okay. What is the impugned order? Page 26. এতে লিখিব paragraph 16 হবো, coming into the impugned order, fair reading of the same reflect the following. Okay. Allowed. with liberty, if so advice,
It's a because crime is very heinous crime.
with a liberty.
Yes.
That's all.
Obliged.
The happened with the light of
I have already quoted.
only the para 21.
Para 21 of which
You lot judge.
we are replicating this judgment.
On it.
Just we'll quote the earlier judgment. We are just exactly similar, even the language.
Yes, ma'am.
Exactly the language, satisfaction, everything is, it's a replica order.
Relative to
That's why I've gone through that thing.
Advice
And-
I did not want to mention.
No, we are, see, Mr. Sutia, this may be a situation where you need to dismiss a person from the discipline. You can exercise
Exactly.
your power.
Right thing. They should
Yes.
they should right thing.
We have not
Yes.
interfered because we give him as clean sheet.
Yes.
We set aside this order because you have not set, you have no satisfaction or requirement under 311. It's a stringent condition. Law is well settled. That much you should advise to your client.
Now they can take it.
Because this is a replica order. I
Yes.
think they have made a format and they will pass this order. That cannot be. If you go into the merit and a satisfaction on the investigation that he is guilty, whole thing gone. That is not the ground under 311.
They could have drawn a departmental proceeding.
They could have drawn a departmental, even under 311, they could have said that it's not practically impossible.
Yes.
We cannot go to the
They are not saying like that. They are
satisfaction. We cannot go to the satisfaction.
they are only
Whether no, this is practicable or not practicable, until unless it is perverse, we cannot go into. You can have a satisfaction.
obliged.
Dispose. CAB, not CAB. Dispose of ethics. Language are better for it. Mr. Rafiq, may not be possible in day or two to upload, huh? Because you'll fine tune it ultimately. Give it. Still alive? Are you sure?
Financial benefit is here the issue is regarding the grant of
SCPS.
yet what has happened is the petition
Just a minute.
for the petitioner he joined his service in the year 1980.
Just let us have a bird's eye view of the fact, then we'll go to the papers.
Under the circumstances, the petitioner is a different chapter. So, the
Okay.
1/1/1983
Mhm. Mhm.
Now, for the then ACP scheme,
Mhm.
it was required to be granted its first financial upgradation
Mhm.
on 9/8/1999. The
Achha, just tell me, where is the, have you annexed the scheme?
ACP
Space.
scheme ACP scheme I have not connected. The MACP
Okay.
ACP scheme what it said was completion of 12 years 24. The person will be entitled to get the just higher scale as given in the RO.
Tell us when first?
12 years and then 24.
8 years, then 24 years.
12 and 24.
12 and 20.
12 and 24.
So if there is no promotion, if there is a promotion, then what will
then
happen?
from the date of the promotion, then 12 years. Here stagnate in one post for 12.
12 years. Okay.
Now, my lord, MSP scheme when it was introduced,
Mhm.
it was there. Now they get three financial upgrade:
Okay.
10 years, 20 years, and 30. Only this will be relevant for
Okay.
ACP is 12 and
12
20,
was MSCP
10, 20, 30.
10,
20.
20. Suppose I tell you one thing.
My lord.
Just for my query. You are at 19th year, you got the second MSc.
I got the
No, 21 year.
20.
You will get in 21st year after completion of 20. Suppose first
20.
you get on 10th.
If I'm from AC,
Hmm.
then first I will get it 12.
No, MSc. I'm saying what
MSc,
MSc.
yes.
Okay, after completion of 10,
10 years I will get one.
1, then 20 years you get 1.
Yes.
But on 21st year, you get a promotion.
Then my third ACP will be counted after I stay for
10 years.
10 years here.
10 years. Now suppose whether you will get promotional, how your salary will be fixed. You will have the promotional
No.
benefit.
ACP MSP scheme does say that I am getting the pay of the promotional post. It doesn't. When the ACP and MSCP were introduced, we had different scales. For constable, suppose it was from 100 rupees to 200. For head constable, it is 200 rupees to 300. In between, there were other scales, 110 to 210. Now, when I'm granted the ACP, I'll be given the 110 to 200. I'm not given the head constable pay. The immediate higher pay that was there in that ROP. So, therefore, to reach that 200 to 300 scale, I'll have to undergo at least 4 or 5 ACPs, which I'm not entitled to. I'll get only 2. So, and what was my last pay? In the promotional post, that last pay will be adjusted and I'll be given 1 increment in the promotional post if I got ACP. If I was at 150, when I'm brought to the MSP scheme, it starts at 100. Say, the promotional post. 100 in the next increment will be 120, so I'll be given 120. That is how it is. So now, my lord, the ACP
So your as per MSCP 10, 20, and 30. Okay.
My lord, the ACP scheme 12 and 24 was introduced in 9/8/1999. That is important. Why? Because anybody who was entitled to anything prior to that, like I had joined in 86, my 12 years would be 1995.
Just a minute. 1983 you joined.
So my 12 years.
So if it is SCP, then your 1st of January join.
1st of January 1995 would have been the date.
1st of January 1995, first SCP.
But since the scheme itself came in 1999,
Okay.
all ACPs will start from 9/8/1990.
So you want to say your earlier period.
That 4 years I lose.
Okay.
That 4 years I lose. If everybody has lost it, I also lost. There is no difficulty.
So 1995 it was your due.
But
however,
for the scheme itself, it will be only given from 9/8/1999.
So it was due on 1/1/1995. Thus MSCP scheme came into SCPs came into force when
9/8/99.
Okay. So 9/8/99.
So retrospectivity was not given. Therefore
99. So 95 due is gone. So your case will start from 1999 for 10 years.
No, that is for 12 years. That is 12 years because the ACP is there. The ACP and the MSCP are separate.
Okay.
If I don't go into
in 83, what was the scheme?
83, there was no
scheme.
No, you are not promoted, you will stay there.
Okay. So it was 9/8/1999.
Government says
first SCP you will get
after 12 years.
After 12 years, meaning thereby 1/1/1995.
But since the scheme has come in 1999, anybody who was entitled prior to 9/8/1999,
their 12 years will be counted from 1999.
He will be deemed to have completed 12 years for the grant of first SCP on 9/8/1999. Now, but the 24 years scheme, the second SCP will be granted counting it from
by 99 you have passed more than
12 years. I will granted the first SCP
only. Okay.
Now for 24 years, the next SCP, they will count it from 80.
Okay.
12 years. So then now the next SCP should have been, if I go like that,
Two- two-
2007.
2007.
7 should have been my second SCP.
Hmm.
But in the meantime, MSCP scheme comes in. This is just for, this will not be very relevant to the case, but it's just to understand how we need to. So now the MSCP comes into play,
Your thing second was due when?
9/8/99. Originally it should have been 95,
Hmm.
but legally it is 9/8/90.
9899 is the first.
Second should have been 2007 from 83,
No,
24 years.
2007. But when the MSCP came? In
MSCP came in
2001.
2000, MSCP came, no. MSCP came in
2008.
112.
2008.
2000.
2009. I'm sorry.
With effect from 2008.
Effect will be from 1/1/2008.
Okay.
So now since the MSCP scheme has come, after I got my first ACP benefit, now what they will do is they will keep it to me on 10, 20th. The first benefit I got in 1999, that is my first benefit.
Though it's 12 years, we take it to be 10 years.
10.
Now second will be according to 12 years, 10, 20 years from 1983. Then
That is ACP finished.
Hmm.
Now with the introduction of the MSCP scheme, it's 12 and 24.
goes
It becomes 10,
10,
20,
20,
and 30.
30.
What is that calculate? 1/1/1980.
So 1/1/1983.
10 years will be
1/1/1993.
but I got it in 1999. 20 years will be 1/1/2000.
You got in
I should get it
Hmm.
on 1/1/2003.
Three.
Third, I should get on 1/1.
now. When they have granted you
My first ACP was granted
1/1/1990, first SCP was granted 9/8/99.
they did not give. That is the whole. They
9/8/99
gave it to me,
not granted.
not granted.
Hmm.
They gave it to me from 26/11.
26/11/2001.
2001 they granted it.
Okay.
Now, my lord, this second ACP that I was supposed to be given,
Hmm.
I was required to be given it from
1/1/2003.
2007.
Huh?
2007, my lord. Under the ACP scheme, 24 years, 1/1/83 plus 24 years.
1/1.
It should be 1/1/2007.
Hmm.
They give it to me on 1/1/2000.
1/1.
2007.
Okay.
Third ACP, after 30 years of service,
Hmm.
so that should have been
17.
1/1/2013.
Uh,
They give it to everybody.
1/1/2013.
13. They give it to all my colleagues.
Hmm.
30 years of service. They do not give. I make a representative. Everybody has got, I have completed 30 years, give it to me. That original first ACP that we had given you, 26/11/2001. If we calculate,
Okay, let us make a chart. When have you been granted? Admittedly granted.
admittedly,
You enter into service on
1/1/1983,
1/1/83. Okay. When have you granted?
I was granted 26/11/2001.
26/11/2001 first.
First, although it should have been 9/8/90.
Okay. We'll come to that. Actually, what then?
Second, I have been granted on 1/1/2007.
1/1/2007. Second.
Third, I
Third.
was not granted. I am fighting for that.
You are, and according to you, that is
1/1/13.
1/1/2013.
I am fighting.
Third,
Correct.
not granted. Okay. In terms of SCP,
It's
Okay,
the first two is in term of ACP.
ACP you are entitled for
First, I'm entitled on 9/8/1999.
9/8/1999 past, that is on completion of 12 years.
12 years, but since the ACP scheme has come in 1999, I'm
Mm.
getting it 99.
Okay.
Otherwise, 12 years is what we are trying.
Okay, 12
Now,
years.
24 years from
12
1183.
Then
It should be 1107,
1/1/2007
and I'm being granted.
granted.
I was
Second,
granted.
this is 1 and 2,
One and
only 1 and 2.
only one.
Now MACP came when?
MACP came in 2008.
One date, any date?
First of
1/9/2008.
1/9/2008.
1/9
Effective.
2008. Okay. ACP came on 9/8/1999, isn't it?
98. Yeah.
Okay. Now MACP came when? 1/9/2008.
Yes.
So first would be, if we count by this first, then your first will be
On 10 years, it
Ah.
should have been 1193.
1/1/1993.
I cannot
Past,
claim it because the MACP says whatever is granted under ACP
already
will not be touched.
granted. Already granted.
touched.
Okay. Then
20 years will be finished in 1/1/2003.
that you have been granted.
I have been granted in 2007 under the ACP scheme will not be touched.
Mm.
So I'm not fighting for that.
Okay.
Third, I should have got on 1/1/2013,
Not granted.
not granted. That is the difference. Sir, I should have been granted on 1/1/13, not granted. Now the fact is, what in 2013, when I make a replacement, they say the first ACP was granted to you on 26/11/2001.
2001. Hmm.
So there was a delay of around 2 years something in granting your first. Once there is a delay in granting you the first ACP, accordingly it will get delayed. The second ACP will get delayed.
Why?
That's what the law says. If the first ACP is delayed, then the second ACP gets.
But it was due on a different date.
It was, I should have got it from 9/8/99.
Huh.
They gave it to me in 2001 on their own pollution. They have not alleged anything from against me till that point of time. They took time in holding the DPC and everything. That delay, they say that since that was delayed, law says if it is delayed, there will be a delay in your second ACP. Therefore, granting you second ACP on 1/17 is wrong.
Hmm.
We should have granted it to you after 2 years, that is from 2009. Granted you, that is from 26/11/2009 we should grant.
Okay.
So we are modifying that order of the second ACP now in 2013. And we are postponing your second ACP, making a recovery, thereby delaying your third ACP also. That is what they try to do. Lordship will kindly have that affidavit.
Now, what is law says? Suppose it is a due. It's no question of doctrine of relation back.
It has to be effective from 9/8/99 is what the ACP scheme said. They have
No.
not denied it.
No, we understand. Just let me understand. Suppose a thing is due because ACP is a due for not giving you a promotion. Okay, for to redress you an that stagnation.
Yes.
Okay. Now they say you will get an ACP after 10 years or 12 years whatsoever. So your entitlement is on reaching 12 years. Okay. But it cannot be straightway, it is not automatic. There must be a DPC. So DPC is held at a belated stage. They decide, yes, you are entitled. Will it not relate back to the original
That
date?
is the whole case, madam. That is what we are trying.
That's a doctrine of relation back in case of promotion.
Now, what they say in the affidavit in opposition, how they try to argue that. Lordship will have the second case.
No, you say that law is that. You said you also supporting that case. That's why I'm surprised.
No, I have to relate back. It has to be from 1999. They cannot keep it at 2001. That is what I'm
Okay,
trying
where
to
is
say.
their affidavit?
Affidavit filed in 27/5/40 by one Nepal.
Yes,
So,
Nemhas Tirki.
fine. Para 5 on the second. The petitioner was appointed in CISF on 1183 as a security. His first SCP was D1 9899, day 29. While he was posted at CISF Unit 20 Jordan. The DPC to grant ACP was conducted on 6/2/2001. Lot people find the DPC was their delay. And he was found not yet fit for first ACP scheme by the screening committee by CISF Unit Jorhat, issued under letter number so and so, dated 10
Due to currency of punishment.
punishment. Now, my lord, they will show the currency of kindly have paragraph 7.
Paragraph 7.
Paragraph 7. See, that is the last punishment type. Others are prior to that. So no question of currency of punishment. Paragraph. Withholding of one increment for 1 year, which will not have the effect of postponing its increment. Right? Final law
7/4/1999.
If the punishment started for withholding of increment for 1 year without cumulative effect, it ends on 27/4/2000. DPC is being held in 2001. Where is the currency of punishment?
No, they may argue you on the due date 9/8/1999.
1999.
There was a currency of punishment
On
on the due date.
the due date.
Ah.
The currency ended on 27.
7/4/1999.
It ended.
So according to you,
My due date was 9/8/99.
okay, 9/8/1999. It postponed
4 months.
prior to that.
So therefore, there was no currency of punishment.
No, that 24/9/20, it is the order dated 24/9/1999. So the
so-
punishment is withholding of one increment of 1 year. So that was during the currency of
So
punishment.
he wants to say that it goes ahead to 2000. Even if it goes
2000, then also
then
it should be
from 28 for
or
2000, I'm entitled to my
28 for
first SCP. I'll be entitled
28 for 2000.
2000. Now, when they take the stand that my second SCP was delayed till 2001, was it? I will lose that from August, September, October, November, December, January, February, March, April. I will lose only 8 months max.
Again, thereafter, DPC of first SCP is conducted on
Again, the effect was conducted on 26/11/2001 at CSF and declared fit with effect from 26/11/2001. Will it not relate back to 27/4/2000? Should have related back.
no, it should have been according to you.
1 year punishment, even if we hold it,
Ha, ha,
ended on 27/4/2000. I become entitled.
Now come to the second financial.
The second financial upgradation under SPC was granted with effect from 24/5/2008 by CSF unit all diligence so and so by adding 1 year, 4 months, and 23 days. Due to late joining of first SCP benefit on account of currency of punishment. Now, Lordship will
Before
see,
that, my lord, previous paragraph, paragraph B, later on, first SCP was amended with effect from 2/1/2001, my lord.
Yes. When was
But
this amendment?
that was declared fit with effect from 26/11/2001. Later on, first SCP scheme was amended with effect from 2/1/2001.
On completion of the currency of punishment issued by 5/4/2004.
That is the second.
Punishment.
Second.
Where is
second-
the second punishment?
There is no second.
No, second
After
financial.
1995.
No, this is the regarding with regard to second financial upgrade. Paragraph B, my lord, page 3.
We have read that. Later on, first SCP scheme was amended with a comma on completion of currency of punishment. Okay, forget what is the amendment? How does it affect him?
That effective has to be that effective amendment, if they want to make it, has to be from the date my punishment ended. 27/6/2000.
So suppose we treat it to be, we accept that
There is
Your
a-
argument is that 27/4/1999, 27/4/2000,
I have to be given my first SCP.
first SCP, then second will be 27/4.
1000 and add another 4 years. Sorry, add another 12 years. 2000, 2012.
2012.
At best, it can be that.
Hmm.
But they had given it to me from 1/1
2013.
2009. No, they had originally given it to me from 1/1 2007.
Hmm.
They,
We'll have to prepare a chart.
yes,
Because first part is according to SCP, what are your dues? Okay. And MSCP, your dues. When have they have given, even if assuming that they are due currency of punishment, what should be your due?
yes.
Just we need a table.
Apart from that, my lord, we need to go to
No,
the-
no, we'll go further. It's not that we are dictating the order. This is his case
No,
to
we are
understand the date.
Ha, ha.
No, we must be satisfied. We're coming back. Wait for some time. Now, let us see their stand again. So, at
We-
first SCP, they take a stand that due to currency of punishment. Okay, this is their first stand. What about the second upgradation?
Second update, he was referring to para B to show that they had done some modification of the date of effect of the first SCP. Thereafter, DPC for the first SCP was conducted on 26/11/2001
Hmm.
at CSA Point Jorhat and declared it with effect.
No, no. They say, as a secretary, first SCP was due on 9/8/1999.
Yes.
That is an admitted provision.
Right.
The SCP, DPC for grant of SCP was conducted on 6/2/2001.
One.
And was found not yet fit
So they did not give me anything.
anything. So 6/2/21 did not give anything
6/2/21 now.
because of the currency of punishment.
Punishment.
Okay. Now therefore they have the DPC on 26/11/2001.
Yes,
Is not it?
yes.
First 6/2, then in the month of November.
Then
And in November they granted
they granted initially from 26/11.
11/2001
Then they modified
Hmm.
to 2/1/2000.
to 1 instead of 26/11 to 1/2001. Okay.
Then
As in
second SCP,
therefore there is a confusion in the language. Later on the first SCP scheme was amended. It's
It
not SCP.
benefit
Your benefit was amended.
effective
Ah.
was amended with effect from 2/1/2001 on complete. The second financial upgradation under ACP scheme was granted with effect from 24/5/2008
Hmm.
by CISF unit Oil Duliajan order dated Lordship will kindly help it. 5/4/2014
14.
by adding 1 year 4 months 23
Due to
due to late granting of first
Hmm.
on account of currency of. Now what they are trying to say, if I understand correctly, is they are saying that my first SCP, which was due on 9/8/1999,
Hmm.
was granted on
2/1/2001.
2001,
Ah.
thereby bringing in a delay of 1 year
4 months,
4
23
months
days.
and 23.
Ah.
Therefore,
They granted earlier.
they made it 24/5 was granted with effect from 24/5/2008. That is when I should have been granted from 1/1/2007,
Hmm.
adding 1 year, 4 months and 23 days. They make it 24/5/2008. That is their argument. Here, what has been done? They have swapped up. I was already granted from 1/1. That is not right.
Hmm.
That was done in the year 2008.
Hmm.
They have modified that year in the, they have modified that order in the year 2004. 6 years after I had already enjoyed all the benefits
Hmm.
without a notice to me. So therefore, my first challenge is that this clause C, this modification done on 5/4/14,
Hmm.
due to non-adherence to the principles of natural justice in giving me a notice and changing the date of a benefit already enjoyed by me for 6 years without any notice is also wrong. So my effective date in my argument would be 1/1/2007. They
From
could not
which-
have modified it. And this they admit that I was already granted from 1/1/2007. Lordship will find yes, page 7, para 11 is possible.
Para 11.
Page 7 of the record. Yes. As regards the statements in paragraph 7 of the petition, the contestant which the petition is categorically denied and is most submitted EPC was considered for granting first SCP with effect from 9/8/99 and he was declared not yet. Again on 26/11/2001, the DPC considered the petitioner's case as he was declared fit by the DPC for financial computation with effect. Further, erroneously he was granted second SCP with effect from 1/1/2007, which had been cancelled subsequently by senior commandant CISF Oil Dubiajan and granted second SCP with effect from 18/4/2009 by Dubiajan order dated 86.
So third was granted on 25/5/2014.
That is what they say, that if it becomes, if my second is counting 10 years from my second SCP, it will be 25/5. Okay.
And according to you, it will be
It will be 30 the year. Now, Lordship attention has to go to 2 points. One, if my first entitlement was of 9/8/1999, whether as on the date when the punishment ended, my first SCP will come. That is on 25/4/2000.
these dates creates. I'm a very, very, very bad in dates, so I want to write it down. Now I understand what is their argument, but dates are creating confusion. Many dates.
I will
So let us have a sequence of dates, including your punishment and all, so that in the left side and right side we can make a difference.
Right.
So appointed, joined on
1/1/18.
1/1/83. And then SCP came into effect
9/8/1999.
9/8/1999 SCP.
Just prior to that, it was put at the date of punishment. So it was prior to 9/8/1999.
Okay, punishment is
Punishment is dated 25
27/4
27/4/1999.
1999.
Or why not?
you don't give SCP, why will not he sleep? 27/4/1999, then 9/8/1999 SCP came.
Comes into play.
In
My
terms of this SCP, let me write down 12 and 24.
Okay.
24. So 12 will be, if we even take it from 27/4/1999, SCP comes on 9/8/1999.
So that is the date I have been entitled. Even if 12 comes in the year 1995. I completed
So
12.
this is 12, if it is 12, 1995, is not it?
1/1/1999.
And 24 is
2007. 1/1/2000.
2007. Why 1/1? Okay, 1/1. Okay,
24.
95 and 2007.
7 should have.
Now, when have you granted first?
Just after the 9/8/99, my punishment ended on 26/4/2000.
Okay. So you have been granted on first. And let us go to the admitted position.
Yes.
We'll go then argument. Now SCP came on 9/8/99. Your first SCPS was granted on.
For then it has been it was
What should we forget about now for the time being?
what they have granted,
Granted.
2/1/2001.
So according to you, first 12 years, you ought to have been granted in the year 1995. They have granted you in the meantime, MSCP camps. MSCP came in there
2008.
2000.
19/2000.
So first granted when?
2/1/2001.
2/1/2001. Okay, so it is under ACPS.
Yes.
Now MSCP came on
MSCP came in 2008. Therefore, my second ACP,
when you,
ACP
uh,
will come in 2007.
so when your second ACP is granted,
1/1/2007.
granted,
Initially granted.
forget about the later on withdrawal. We'll go to the because withdrawal date is 2013.
Yes.
Okay, so we'll
So
go
I'm
sequence.
1/1/2007.
1/1/2007.
Seven.
You have granted SCP
24 years.
24 years. Fine.
Thereafter, MSCP comes
MSCP comes when
1/9/2008.
1/9/2008. Now in terms of MSC 10, 20,
30.
and 30.
So-
Now what did they do?
My effective date should have been 1/1/13. They did not grant it.
1/1
30
for the second,
for the third.
for the third. 1/1.
13 should have been the date.
Date.
Not granted.
Okay. Because in the meantime, you have been granted 2 benefits under ACP.
ACP. Third will come
Now
under
we understand 1/1/13 due, not granted. Now what happened?
They say
They passes some orders. Now come to 2013, they have passed an
Right.
order withdrawing earlier.
yes. Earlier order.
What is that order?
Their
dated?
affidavit says
Hmm.
by order dated 18/3/2013
Withdrawal, no?
withdrawal
18.
3/13.
What is the effect of this?
My second ACP comes from 18/4/2009.
Second
ACP is
should
changed
be, according to them, 18.
4/2009.
Okay. This is they have done. Thereafter, what they did, they say
And-
that 13/1/1/13, you are
They
not
have not
attached.
granted. They have now in their affidavit on the same paragraph said third ACP MSCP granted
Hmm.
25/5/14.
So, 25,
5/14.
5, 14. This is third.
Third.
According to you, third should be
1/1/13.
1/1.
13. Or if we take the punishment part also, then it will become 25/5 5
25, 5.
13. That is what it.
So, what is the relief sought?
And my relief sought is directing the respondents to correctly fix this pay at the initial stage of granting first financial application under the ACP scheme with effect from 9/8/1999. That is from the date the effect in the ACP scheme has certified preempted demand. And further to grant the financial benefit under MSP scheme to the petitioner on completion of 30 years of service with effect from 1/1.
So, you have been paid 2 SCPs, 1 MSCP. MSCP paid on 1/9/2008.
MSCP.
No,
MSCP is paid in 14.
One,
ACP is paid in 1/1.
1995 and 1/1/2007.
Yes. Those are
MSCP
ACP.
paid in 14.
14 years. MSCP
It was according to you, it was due on 1/1/30, not granted. Granted on 18. Got granted on. Third granted on.
third granted with effect from
18/5/14.
25.
25/5/14.
Okay. 25/5/14. So you want your third MSCP from 1/1/2013. That is your case?
Yes.
or even if it is punishment, then 25/5/2005. And they have given you from,
25 or 14. One
they have given you 25/5/14. There is a gap of 1 year.
1 year, 1 year pro.
No, 25/5/13,
With the punishment is
25/5/14, they have given you 25/5/14. Why this 1 year they have not given? What is the reason?
they say that in 1999 I was undergoing the punishment.
99. So a 1 year more was given.
So that part, the punishment part. My argument is on the day the punishment ends, is the day I become entitled.
Yes, Pegu, that is the case. Your case is also that. Give a list. I'll not dictate it today.
May I file a written argument?
File it. It's better for us.
Before that, I'd just like to draw your lordship's attention, my lord. Conditions for grant of benefit under the ACP scheme. Hard case of it.
Hard pace. Okay. Cross board.
My lord. The first financial upgradation under the ACP scheme shall be allowed after 12 years of regular service, and the second upgradation after 12 years, that is 24 years, from the date of the first financial upgradation, subject to fulfillment of prescribed conditions. In other words, if the first upgradation gets postponed on account of the employee not found fit or due to departmental proceedings, etc., this would have consequential effect on the second upgradation. We should also get deferred reporting. So that punishment part.
Understand? So you say that if it is due to currency of punishment postponed to 1 year,
My lord.
subsequently the second will also go to the 1 year, it will be delayed.
Delay, my lord.
Then 8.
Treatment. The financial operation under the ACP scheme shall be purely personal to the employee and shall have no relevance to his seniority position, because the
No,
petition
that
has-
is not a case here. No relevance.
but they have stated in their petition, my lord.
I have been paid less than my juniors is what I have paid. I'm not asking, they're not disputing, I'm not asking for this. You're telling me, paid less is what.
That is a, give a small written argument and clarify that position.
My lord.
In a small, you also give.
Date wise,
Ah.
according to me, according.
So both the learned council have concluded their, oh, sorry. Give a sequence of dates, both admitted position. Then you put in other way why, what should be and why. And they will also give, this is the dates, this is the reason we have deprived. That's all we will now decide. So both the learned councils for the parties has concluded their argument. It submits that they would like to further address this court with further this argument and to submit written argument. Accordingly, matters that's adjourned and be listed on 8 of February 2024 of order hearing
I'm obliged,
and submission of written argument.
I'm obliged.
Musumi, keep this. It is important. I consider misplaced now. Okay, Mr. A.R. Padgiri, Learned Counsel for the petitioner submits that he has recently been engaged in this case. Accordingly, seeks some time to advance his argument. Not 14, uh, uh, though matter is a old pending matter, however, in the peculiar circumstances, adjournment short for is granted. List this matter. 22nd of February. You have the record. The learned counsel for the bank shall keep the record of the departmental proceeding ready on the date of hearing.
Okay.
Sir, participant is from service without section.
What is the rule? What the rule says?
The termination of service stated that the trial by the fourth court is unexpedient. Due to that, John Malot terminate the petition without following any procedure.
Where is that? Where is that?
21B.
Where is that?
Rule 21.
Give the book. SSB rule. SSB Act and rules. This is something new for me. That's why. What is that rule? Act section?
Rule, Lordship will come to the rule 21.
Rule
21.
just a minute.
Yes, keep.
21. Two.
Rule 2.
Okay. Like the 311 clause
311.
B clause after clause. Where is rule 18?
One page ahead, page 55.
The rule 18 is the who will issue the order, not so
That is
relevant.
not relevant. Only thing Lordship has to see whether
Okay, they have a power to do this. Now let us see how the power is exercised.
the work can be
If power is exercised as per rule 21, 2, we cannot say that this satisfaction is wrong. Okay, let us see how it was started. We understand FIR and all, that was you were arrested, that we know. Then
Captain Day was released on bail, my lord.
Hmm.
And thereafter, my lord, he resumed his duties, my lord.
Hmm.
kindly see my lord notice for dismissal, my lord, page 27.
Page,
27,
running page.
running page. I repeat it at 27. Whereas the ultimate third paragraph, whereas you have committed a criminal offense in that while you are serving with the 31st Battalion SSB and office Tokompur, made contact with the cadre of anti-extremist outfit. It is the my lord, stated in the FIR. The basis of that FIR, my lord, the
Okay, where is your reply?
reply, my lord, thereafter page 29.
Just
By paragraph 4, category stated that other the honorable court while getting the bail stated that no material could be cited. Second thing, my lord, did that no charges has been filed by the Portugal PS. Did that paragraph 5. Government already stated that we have committed a criminal offense. Ever proved by the trial court. Then, my lord, no charges has been
are you having the record?
A lot of original records that not happen. Okay, maybe a fact.
probably enter and if record, my
During
lord,
during the interrogation, okay, where he had, I was that he had communicated the movements of the floor with the NDA. So that the lordship.
No, we are not on there. Basically, rule 21, you have a power
yeah.
to terminate without departmental proceeding. Okay. You must have certain satisfaction.
court of inquiry was conducted, my lord.
No, no.
Finding, my lord, the findings of court of inquiry.
We'll come to that. Let us first. Let us first understand what is the mandate of law. Rule 21(2). So, there must be a consideration of report of misconduct. Okay, first point is, after considering report on misconduct. Okay, after considering report on the misconduct, the authority under Rule 18 is satisfied that trial of it, he will have to have a satisfaction that trial of such a person by force is inexpedient or
Court,
impracticable.
Court.
Fine. Force court or is inexpedient or impracticable. True satisfaction. Part is of the opinion that his further retention in service is undesirable. It shall so inform him together with all reports adverse to him and shall be called upon to submit. So you will have to intimate him, see, it is not expedient and we do not desire you to be here. These are the reports. You, whatever reply you file. We are not going for a departmental proceeding.
No.
Now you do that under, where is that communication? Notice 21.
Page.
Page
27.
7.
Page 27.
7.
Okay, what you say?
Paragraph
So
3.
their report is
With the notice, my lord.
just no,
Paragraph 3.
no, paragraph 2.
Paragraph 2.
Paragraph 2, their satisfaction is on the basis of the report by Superintendent of Police, Kokrajhar.
Yes, yes, so it's been registered.
Okay.
Paragraph 3,
You have satisfaction that
The
you have
criminal
committed a
offence.
criminal offense in that you were serving in 2020.
my lord, it has to be proved, my lord,
No, no, not necessary.
but it's a
Yeah,
committed
Because
offence.
this power is given in such a situation. That satisfaction we cannot replace. Okay. Uh, and committed secret information regarding strategical movement of security was 2022. Since your mention is act is punishable under section 3 of the official secret, whereas the understanding is the opinion that your retention of service is undesirable. But there is no satisfaction reflected in this record that it is not practicable to hold an entity.
that-
So, therefore, if that satisfaction in the record, we may wash off our hands. You should see some judgments. Law is clear. We have also passed judgment. Even we have set aside Mr. Dhar is also there in that police constable case. But in case of 311, it's like a similar provision of 311 2B, where the departmental proceeding can be dispensed with, where they will have a satisfaction that it's not practicable or this is this. Now, Supreme Court says yes, they can have that satisfaction. But there are certain parameters which we have to look into. We cannot say that they cannot have that satisfaction. Only will go for the procedure. Their satisfaction, if it is absolutely without any material, of course. So therefore, a record is required.
Lordship, I can produce the. I give you.
Okay.
For a
But-
moment, but at
but
the
here
court
what-
of inquiry, there is a court of inquiry. And finally, the page, my lord, the running page, my lord, 65. Reflecting the affidavit opposition filed by the respondent,
Yes.
65. And my lord, inner page 21 of the affidavit in opposition.
Page 65.
Proceeding of court of inquiry.
Just a minute. Okay.
Next, my lord, the finally, see, my lord, page 68, opinion part.
Hmm.
However, it is not clear as
Where is
to
that?
whether
Where is that?
page 68, my lord, and inner page 24. Opinion and recommendation of the court.
Just a minute.
Paragraph S as the court
Just go slow, go slow.
opinionate comment that whether has it to wait
Just a minute. Let us see what is the we directly going into the conclusion. Let us see the whole thing. This is not a court of inquiry. This is a preliminary fact finding. Though they have named it a court of inquiry, this is not a court of inquiry. This is basically a fact finding to understand what is what.
Here, court of inquiry, both person is absent. Court of inquiry is just to determine whether he is absent or not.
This is a fact finding,
This
kind
is
of a fact.
basically fact finding.
It's a fact finding. On the basis of that, they might have a satisfaction.
Yes.
It's stated in the dismissal order, my lord. Stated, my lord, page 31.
Yes.
For a moment.
Yes.
Lordship is seeing the inquiry. Okay. Lordship will come to page 67.
What is the page 31?
Page 31, my lord. Dismissal order. Paragraph 6. Hereby order for your dismissal.
Have the record. You want to say something?
I was just trying to, Lordship was looking at the report.
Page
65. It starts at page 65. So just for a moment, draw your attention. So page 67. Lordship will see E. E. And then after below, Lordship will see C. Now, he is during the interrogation with the SSP personnel with along with it was a joint interrogation where he had accepted that he had disclosed the movement of the company. And in any case, if this has to be again substantiated by evidence, we have to call in that Philip Wari. So that is I'll get the
You get the record. The petitioner was terminated from service in exercise of power under Rule 21 within bracket 2 of the SSB Rules 2009 for alleged involvement with the terrorist organization within bracket NDFB and linking the movement of higher officials to the NDFB cadre. Full stop. The impugn orders reflect that reflects the satisfaction of the employer that that retention of the petitioner in service is undesirable. And that undesirable. However, in the order there is no in the order of dismissal there is no specific satisfaction is reflected that trial of the petitioner by the force is inexpedient or impracticable. Referring to such fact, Mr. Padgiri has argued that, in fact, a court of inquiry was conducted and the court of inquiry recommended not to take any action against the petitioner. However, ignoring such court of inquiry, the service of the petitioner was dismissed. The petitioner was discharged from the force in exercise of power under Rule 21 within bracket 2 of the Rules 2009, which is very stringent in nature and should be treated as an exception, not as a rule. Full stop. Full stop. This court, after hearing the learned counsel for the parties, is of the opinion that for the proper adjudication of this case, the record pertaining to the dismissal of the petitioner under Rule 21 within bracket 2 of the Rules 2009 shall be necessary. Mr. R.K. D. Chaudhary, learned ASG, what you call now? ASG? DSG, learned DSG, 6 for 10 days, 2 weeks. 2 weeks time to produce the record. Prayer is allowed, list after 2 weeks. List this matter on 22nd. You see how this power should be required to be exercised. You'll have to satisfy us that requirement is not, because we are not sitting as an appellate authority. You'll have to satisfy it's akin to the Rule 311 2B. There are some important judgments on that. One judgment I have also passed. I will not say that is an important judgment, but Supreme Court judgments are there.
Right.
Before my friend start, so last occasion is Honorable Post directed Mr. M.M. Kotok is a clinic counselor. So he informed me so some difficulty on her part today. So he pays so little accommodation for only for the two days.
In fact, the Animal Husbandry Department is not the party in this case.
Not the party, but this person was he retired from an animal husbandry.
Animal, but the issue is relating to the promotion from ACS senior.
So you say that we need not hear animal
Yes,
husbandry.
Lord.
So we'll delete the name, risk is yours.
My lord, I can take the
Huh?
answer, my lord. Because only he was,
Okay, we'll delete this.
my lord.
If you are objecting
the
to
last
that.
question, Dr. I was not there, my superior was there.
Because as per the last order, it is for the
That is,
hard
I have
administration.
seen,
Yes, it was raised that he
So we'll
retired from
delete it at his risk.
my lord,
Later on, don't say anything.
my lord.
We'll record it.
was, my lord,
Now who will contest this case?
My lord,
I'm there for personal department, my lord.
this matter
Mr. Khan, learned counsel for the petitioner, submits that respondent number 2 is not a necessary party.
no, respondent of the court is personally.
Then where is the
Well, Animal and husbandry department is not even the party. That's why.
that is not a party, not a party. Why should their name be shown? Who made the submission that
My lord,
veterinary is necessary?
the person petitioner retired from this department, my lord.
If he have not made a party, why should you argue?
My lord, my lord.
Though this court under its order dated 18/1/2024 directed directed to reflect the name of Learned Standing Council for Animal Husbandry and Veterinary Department in the cause list. However, Animal Husbandry and Veterinary Department is not a party. Is not a party in the proceeding, not a party in the present treatment.
My lord will peruse the order dated 12/12/20. No, my lord.
Why should we hear this matter? This is 2019.
19 matter. This man has retired already, my lord. My lord, long
Are
back.
you getting pension?
My lord, I'm getting that.
And what do you want?
He
Whatever national.
wants promotion, my lord. He has retired in 2012.
Yes, I say. My lord,
Which order, Mr. Dhar?
My lord,
this case,
my lord's order dated 18/12/23.
Why registry is giving 2019 matter, 14/12 matters are
Lord,
pending?
I file an IA for early hearing because this case was initially filed in the year 2012.
We'll see, is there any case like you, retired person seeking increment? We ask the registry to verify and then list all these cases together.
That's what comes to. My lord, this person is lordship 72 years. He
Maybe.
retired in the year 2011.
You have retired.
Right.
You are getting your pension. All
Everything.
things you cannot get at the same time.
But,
People are in the queue.
in fact, lordship, he has been deprived lordship from the benefit of promotion.
When?
My lord, 2011.
Why have you not challenged?
No, lordship, we have challenged.
Then?
2012 lordship. Thereafter, in the year 2019, the matter was remanded to the government. And the government has passed the MP note. Subsequently, we challenged this order in the year 2000. This case lordship is continuing from 2012. That is, if your lordship kindly come to page 42, that is the earlier order.
Affidavit file?
Yes, earlier order. This case 2012 disposed on 10/5/2019. It's not a new case. Start from 2012. Because of wrong calculation of the vacancy.
My lord, that has to
I
be,
have been there.
that has to be ascertained, my lord. My lord will just peruse the order. It is 18/11/23. That is my lord. 18/11/2023. My lord, in another writ petition, here in our writ petition, in this affidavit, we have stated that there are 4 vacancies.
Hmm.
In the
1811?
18/11/23, my lord.
11 and 12.
12 is sufficient. Main is 18/11.
Whether that is available on record.
No, my lord. That part we have written a letter to the department. That has not come, my lord. But earlier we have already filed our affidavit. That position we have to clarify, my lord. That let me, my lord, get the instruction and place it on record. Because in our this affidavit, my lord, filed by the respondent, my lord, we stated that there were 4 vacancies.
But actual vacancies was about 7 that was left. Total vacancy was 20, but they have assessed 17 vacancies. File 200.
There is an order. 1811.
1811, if you lordship kindly come to page 12 here, 2023. That in terms of earlier order, this honorable court has directed them to clarify that paragraph 9 of the earlier order.
Where?
12,
Uh,
2023.
order 11/12/2023. So you want to tell us that without this instruction now we can proceed today.
No, but I am not saying.
So let him have the instruction. Who made this submission that standing council is required without being a party?
My junior did not make some.
My lord,
I was so sorry, Lord, I'm sorry that I could not appear on that day. I was in back in another court. My junior it.
the petitioner,
Perhaps the Lordship government side that something.
maybe my lord, we for that animal husbandry.
Okay. Okay, Mr. R. Dhar, learned counsel for the petitioner seeks for further 10 days time to obtain instruction in terms of this court's order dated 18/11/2023. There is allowed, please this matter after 10 days. Let it come and say, we have already passed an order.
Date was
1919, wait for something. Make a mention.
Yes, my lord, after long hearing, my lord,
Hmm.
the admission statement, this one was disposed of.
Hmm.
But my learned friend also filed review that was also, and the appeal file, my lord, again demand back the matter. Actually, my lord, it is a violation of the selection and appointment of the Anganwadi worker. And here in this case, my lord, the petition was allowed, my lord, because it is against the my lord, guideline. There was a clause, my lord, clause 2 of 2, Roman.
What you want to argue?
Already he is, my lord, working there, my lord. In the
What you want to argue?
Minister.
My lord, point is, lord, as per guidelines, lordship, the post was reserved for my lord, civil custody, my lord. My lord, I'm coming to that. Post is reserved for my lord, civil custody communicative candidate. My lord, in the advertisement, my lord, that clause was not there. Lord. My lord, generally, all my lord, five candidates who don't my lord have my lord specific
Who is for the state?
candidates appeared. Lord. My state earlier, Mr. Goswami was there. Clear. Now, the selection committee, my lord, as per guidelines, my lord, appointed the petitioner as my lord, candidate, lord. There was a specific,
How can that be?
Yeah.
If it is not advertised,
my lord.
everything will go.
there was-
There might be
Subsequent
some
decision,
other
madam.
scheduled caste candidate.
Subsequent decision is also annexed there by
My
the
lord.
government.
There was, yeah. My lord, there was a meeting, lordship. In that meeting, it was decided that as per guidelines, there is a guideline to appoint
So
the.
there is a mistake, cancel the advertisement. How can you
No,
appoint?
that was nobody can challenge that advertisement, lordship. So subsequently,
Suppose the stone of Article 14 and 16 is that there must be equal. We'll go detail now, detail.
Lord.
Advertisement says generate. Many
Yeah.
of the scheduled castes might not have applied. What will happen to those
petitioner
candidates?
applied, Lord. Petitioner applied.
Forget about the petitioner. So other persons, can you change the rule of the game subsequently?
My lord, this was not subsequently, Lord. Rule was early, government guidelines
No,
was prior
Gordon
to that.
guidelines was there, but in the so they ought to have said no, there is a mistake. Cancel this advertisement, issue a
That
fresh.
was not, there's a Supreme Court judgment, lordship.
Oh, Supreme Court judgment, we know. Tell your facts.
Well, that is the fact, lordship. That is the fact. The selection committee considered the petitioners the candidates, sir, and he was appointed, Lord.
As a scheduled
No.
caste.
Yes, Lord. As a scheduled caste candidate.
Who got more marks?
The,
He or she or he? Her?
the fact, my lord, did not challenge, lordship. Nothing, no dispute was there that the post was reserved for scheduled caste candidate.
What is the advertisement?
Advertisement, lordship.
That is in the writ petition law page 15, Lordship.
Just separate ticket.
Page 15, it was my lord filed by the petitioner, Lordship. Is a notice, Lordship. Where is the advertisement? Detailed advertisement.
The detail of it is in the document.
Additional affidavit probably was filed, Lordship.
Serial number
What is the center here?
465 Puroni
Puroni
Kolitapara.
Kolitapara.
Serial number 5.
5. In terms and 5 অংগনবাদী কৰ্মী সম্পূৰ্ণ মেধা ভিত্তিত বাছনি কৰা হ'ব ক্ষেত্ৰত
Okay, where is the selection committee procedure to appoint you?
last phase of the affidavit opposition filed by the government on 7/9/21 last phase. There is
Affidavit by Chandra Kolita. No,
Chandrama Kolita. It was filed by one Nilotpal Bora.
Chandrama Kolita.
Last phase.
Nilotpal Bora.
Yes. Bora Das. Nilotpal
Nilotpal Bora Das.
53. It was on 22.
Just a minute, just a minute. Where is that official notification?
That is at page, Lordship, 10 of the affidavit filed by the respondent 1 to 5.
No, in,
Page 10, Lordship.
and related to that portion, my lord, what is mentioned, my lord, page 17. Procedure clause
That advertisement date kindly be seen, Lordship. That date is, Lordship, 25/1/2019.
notification.
Yes, government guidelines. 25/1/2019, and the advertisement was, Lordship, 16/2/2019. Earlier, Lordship. That is before the my lord advertisement. Lord.
Here it is
Now, page
mentioned.
17.
Clause 2, list of such center must be published at the time of advertisement made by the child development.
Just let me. Don't argue both the council.
My lord, whether me or my learned trained law.
Okay, or you both take your seat. I am
Lord.
reading the file. You take your seat. It's better to read myself. Where is that SC/ST consideration?
My lord, page 17. Page 17, Lordship,
Okay.
close 5. At the bottom, Lordship, instruction was there, Lordship. The selection committee shall select the candidate for the post of Anganwadi worker in the mini Anganwadi center and helper, considering the clause mentioned above in the para point 2. This is the criteria for selection. Point 2 starts from 15.
According to you, who did the survey?
My lord, this is the, my lord, actually it is to be done by the CDPU in presence of the
Where is that?
Anganwadi worker. Lordship.
Where is that?
Any,
That the procedure.
Yes.
That having more than 40% of the SC/ST tree population shall be from the amongst the said majority community.
Yes.
That this belongs to a minority committee, and that list of such centers must be published at a time of advertisement made by the child development inviting application for such. So therefore, two stages are there. One, a fact is to be determined that this is a center where majority community is SC, ST or T tribe.
Lord.
That cannot be by a selection committee that these are majority. There must be some actual survey or on the basis of some survey. Okay. Okay. So there must be, then it should be notified. It should be notified. See, this is a area. Selection committee will come and say this is a 40%. Where have they got the power? You show us. If they have the power that no, then we'll see.
Must
And-
be, my lord, some survey, Lordship. Otherwise, my lord,
No, we'll see that now. Now let us come to the proceeding. Selection proceeding.
Yeah.
Where from they have the satisfaction that this is 40%. If the
it
satisfaction
is
is
not disputed, Lord, this is 40%. Lord. It is not challenged. It is no dispute is that.
oh, let us see their satisfaction.
It should be there. It should be
They
there.
may say the sun rise in the
Yes.
west. There is no objection that will sun
That
run
must
in the
be
west.
lawfully-
So there must be some satisfaction. Where is that selection committee meeting?
My lord, meeting is there, my lord, my notes, page 21 starts, Lordship, up to 30.
Okay, we'll come back. Show us that.
Okay.
Straight to this annexure 1, page 6 of my affidavit, my lord.
Annexure 1, page 6.
Page 6, my lord. So, my lord,
Okay.
so SC, the total population is 272. SC is 131. 40% of 272 is comes to 108. So it has exceeded, my lord.
Mm-hmm.
272 is the total population of the center, my lord. SC is 131. If you go by this 40% benchmark, then 108 is the benchmark, my lord. So we have 131, meaning thereby it has exceeded. So it's a SC, my lord, dominated area, my lord. That is there.
When have you issued this certificate?
This is in my lord 21.
When was the advertisement?
My lord, the survey is of April 2018. The certificate is issued on 21. The survey, if I read from the top, my lord, the survey done by Begum Surveyor under Dudhna ICTS project Rangoli in the year April 2018.
Produce the survey report.
Survey report.
We smack Melaf ID here.
Right.
Not only survey report, even in the existence of service report, whole selection may go. Even if we hold that this is a SC/ST is required, how will you allow participation of the other candidates? Where is Article 14 and 16? As a instrumental, forget about her thing. You know, on 2018, that is, this should be for, assuming for your moment, your argument, you know that this should be advertised for scheduled caste. Okay. Admittedly, you don't notify that this center would be meant for scheduled caste.
We do not earmark. That is,
You do not earmark. Now you have a selection. Now let us see the selection committee procedure record. Let us see minutes of the selection committee. Where is that? That they have
this is
decided to
in
have
page number
Huh.
21, man.
page 21.
The translated. Copy, my lord.
Okay.
Not 21, 23, man. Today on 4th meeting was that 23, man.
23 is the today 4 to 2019.
19.
Isn't it? No,
Yes,
this is
the-
not that. This is prior to advertisement. This is prior to advertisement that these are vacancy. We'll have to do this. There is nothing is mentioned that this is there was a existence of a survey and it should be a scheduled caste. Then give the resolution.
22, 22, 19. This is page number 22. Wonderful. তুমি ফাইনাল করতে করি দাও। I have just
আজি সভায় 45 পুৰণি কলিতাপাৰা অংগনবাড়ী কেন্দ্ৰৰ HS মাৰ্ক শ্ৰীমতী চন্দ্ৰমা কলিতা প্ৰাৰ্থীজনী প্ৰথম স্থান পালেও উক্ত কেন্দ্ৰ এলেকাটো 59 SC মানুহ থকাৰ বাবে SCৰ বাবে উক্ত এলেকাটো সংৰক্ষিত গাইডলাইন মতে 40% উত্তৰ হলে SC STৰ বাবে সংৰক্ষিত বুলি গণ্য কৰা হয়। এইবাবে সৰ্বসন্মতিক্ৰমে উক্ত কেন্দ্ৰৰ বাবে SC কৰা হয়।
We want to have the selection record.
Subsequently, my lord, after 7 days, after 7 days of the selection, they have taken this adopted.
We'll see those dates
Yes.
later on. What was the date of interview?
Interview, my lord, 21 to, my lord, 21 to 20,
19.
19, my lord. And appointment given 21, in the year 21. After collecting all those documents, my lord, they have given appointed on 38 to 21.
See, Mr. Dhar, come to page 45 of your affidavit, internal page 21.
mine.
The selection was held on 22nd,
22nd to 19.
19. 8 numbers of candidates' name appear has been left out. And after discussion, the committee decided to take interview left out candidates. The name of the candidates and code of dates are given below. Chandrama Kolita, 4. Why left out? How her name has come? Second resolution. Then Rina Das was also there. Now, how it visually left out. Then they decide Heard Mr. H. The Flooded Council for the petition. Also heard Mr. R. The Flooded Council for the official respondents. Mr. Islam for the respondent number six. Respondent number 6. The challenge made in this writ petition.
Right.
No, challenge made to the writ petition is to the appointment of the respondent number 3 to the honorary post of Anganwadi worker in 465 Purani Kolitapara Anganwadi Center. Full stop. Admittedly, the petitioner obtained the highest mark. However, her candidature has been rejected and the respondent number 6 was selected on the ground that the respondent number 6 belongs to SC category candidate and majority of the population under the Anganwadi center, not majority, for more than 40% of the population under the Anganwadi center belongs to scheduled caste category community. It is the case that the guideline mandates that when population is more than 40%, the post of Anganwadi worker should be reserved for scheduled caste candidate. Full stop. The advertisement was silent about reservation of the as advertisement is silent over such reservation. Rather, it mandates that the most meritorious candidate shall be appointed to the post in question. The notification, the guideline, the revised guideline on the basis notification dated 25th of January 2019, on the basis of which the petitioner was petitioner's candidature was rejected, also mandates that for Anganwadi centers / mini Anganwadi centers located in village / locality having more than 40% of SC, ST or tree type population, the selection of Anganwadi worker / helper / worker / helper shall be made from amongst the majority community. The said notification further mandates that list of such center must be published at the time of advertisement made by the child development officer inviting application for such candidates. However, admittedly, no such publication was made at the time of advertisement. The resolution on the basis of which the candidature, the resolution by which the candidature of the petitioner was rejected is also silent regarding the basis of the satisfaction of the selection committee that majority selection committee that the village / locality is having more than 40% of SC population. Though a certification was relied on by the respondent state, which is issued by the issued by the who? Where is that?
It's been seven at the bottom.
Uh,
CDPO Dudhnoy ICDS project.
Issued by the CDPO Dudhnoy ICDS. However, the same relates to same dates. Same is dated 2/9/2021. That is subsequent to the selection process. Full stop. The said certification reflects some survey done by supervisor under Dudhnoy ICDS project. However, same is not part of the record. Full stop. In view of the aforesaid, the learned Mr. Ardhar Learned Counsel shall produce the record of selection, produce the selection record pertaining to the selection of Anganwadi worker under 465 number Purani Kolitapara Anganwadi Center, along with the survey on the basis and along with a copy of the survey on the basis of which such certification was issued. Full stop. Mr. Dhar shall also address this court on the next date fixed whether it will be permissible for the selection committee to select a scheduled caste candidate ignoring a more meritorious general candidate when the advice do not prescribe for selection of a scheduled caste candidate in terms of the notification question. Full stop. Please this matter on 27th of February 2024.
Otherwise, Lordship, the petitioner is not eligible. Lord. Otherwise, the petitioner is not, my lord, eligible, my lord. Apart from
Why?
the advertisement, as per guideline.
Why?
As per guideline, he is not, she is not eligible.
They have not, selection committee has not said, we cannot go by you. Has the selection committee said that he is not entitled? They said she is meritorious, but we are not giving her because of.
As per guideline, guidelines does not permit.
Huh? So
Guideline,
can we have a satisfaction as a read code that no, there are additional grounds?
guideline does not permit.
Earlier it was repetition allowed, my lord.
No, we
If
not.
you also dismiss 13 times.
No, that has been set aside.
Not
Once it is set aside, you missed the code. You see the judgment properly. It was quashed and set aside. Once the judgment is quashed and set aside, it has no code.
We come better prepared than you. Unnecessarily do not argue.
Obviously, Lord.
Like the Uganda, this primary worker, there is such a place for this post everywhere.
This is not even post. These are voluntary.
And voluntary service at 3,500
Reasons are somewhere else.
somewhere else. That is exactly.
But what to do? That's all.